Well, that's the cue. This is the WSLR newscast music, and that's the cue for us to begin, I believe. So, welcome to the fifth and second to last of WSLR News Public Newsroom series. Our not-so-hidden agenda here is to animate you to engage with journalism and maybe even become a journalist yourselves. That's obviously through WSLR News. We are volunteer-driven. Our newscasts are mostly produced by community journalists that are volunteers, and we're always looking for more. I'm glad to see one of them here, front row. Welcome, Gretchen. In that vein, welcome journalism law and ethics. Boy, Florida has tried to produce a new defamation bill again. It failed. Journalists would have been the main target of that, but it may come back again. And there are landmark defamation suits nationwide. Just to mention two is Carroll versus Trump, and another one is Dominion Voting Machines versus Fox News. I'm not so sure who to really root for in that last case. And then there is politics. Journalists continue to be the political punching bag. When candidates talk about fake news and hoaxes, they usually don't point at social media actors, but rather at mainstream news and news organizations in general. But there is also a reason why political candidates can use journalists as punching bags, and that's the public perception of journalists. The trust in media organizations is fairly low. We do have experts here who can talk about all this. But before I introduce them, I have a few household items. First is a thank you and a disclaimer. Funding for this program was provided through a grant from the Florida Humanities with funds from the National Endowment for the Humanities. Any views, findings, conclusions, or recommendations expressed in this program do not necessarily represent those of Florida Humanities or the National Endowment for the Humanities.
Clay, does that mean the endowment cannot be sued for defamation?
I think that's what we're doing right there. It's the Florida Manatees, did you say?
All right. We do have a questionnaire. It's on your table. That's for the Florida Humanities. Please fill it out after this event. It helps our funders and it helps us. And to the order of events, the first half will be dedicated to conversation with and by the panelists here. We'll try to get you out by 7:30. That means the second half will also take 45 minutes, like the first half. Please use the microphone when you speak up. That's also to the panelists. Be as close as possible to the mic. There will be a microphone next to the stage for you to ask questions and make suggestions. Back to our experts. So, by the way, we have interesting participants in the audience as well. One of them is Mike Barfield. Sorry to put you on the spot, but his organization, the Florida Center for Government Accountability, broke the news on the Zieglers, and his organization will have a fundraiser tomorrow if you're interested to talk to him about that. He's right in our midst. All right, introductions. Joy Mayer founded Trusting News in 2016. That's a project that studies how people decide what news to trust and helps journalists and the public understand each other. She struck out on her own after a 20-year career in newsrooms and in teaching. She's yet another former reporter of the Sarasota Herald Tribune on this panel. And she spent 12 years at the Missouri School of Journalism, where she created an audience engagement curriculum and a community outreach team in the newsroom of the Columbia Missourian, and also taught web design and print design. She happens to live in Sarasota. Clay Calvert, on our right, is a non-resident senior fellow in technology policy studies at the American Enterprise Institute. He's also a professor of law emeritus at the Levin College of Law and Brechner Eminent Scholar Emeritus at the College of Journalism and Communications, both at the University of Florida in Gainesville. Considered one of the foremost experts on First Amendment law, Dr. Calvert is often a source in writings about the First Amendment and freedom of expression. Dr. Calvert has authored or co-authored more than 150 law journal articles on topics related to freedom of expression. He has published articles in journals affiliated with law schools, including Harvard University, the University of California, Berkeley, the University of Virginia, the University of Pennsylvania, Columbia University, Duke University, and Georgetown University. In the popular press, his commentaries have appeared in CNN.com, Fortune, The Hill, Time, Newsweek, and New Republic, Orlando Sentinel, The Conversation, and Tampa Bay Times, among others. In the middle, James Lake. Jim came here from Tampa, where his practice focuses on media law, intellectual property, and business litigation. Jim represents clients in state and federal courts and the U.S. Patent and Trademark Office, and he frequently gives advice on news gathering, trademark, and copyright matters. His clients include media and well-known authors. Jim has litigated defamation, trademark, and copyright cases, trademark opposition proceedings, reporters' privilege disputes, demands for access to public records and meetings, domain name proceedings, and commercial disputes. And Jim regularly serves as local counsel for businesses sued or pursuing claims in the Middle District of Florida. Jim graduated from Washington and Lee University with honors in journalism and then worked as a reporter for the Tampa Tribune. So he's gone the opposite way of what I always say. The favorite reporters and columnists I've worked with are burned out lawyers. But you still have a chance to go the other way again. All right, let's get started. So, my first question is to Joy. You are all about helping news organizations build public trust. Why is that good business for you? And what are the trust deficits that news organizations face?
Sure, small question to begin with. I will say that when I was pitching this project and deciding that I wanted to learn more about trust and how people decide what news to trust, it was 2015, and I did not expect to still be in business in 2024. I thought this would be something I worked on for a while, solved some problems, and moved on. I began working in it because as I was working in engagement for a local community newsroom in Missouri, I realized that more and more people didn't have trust in the basic integrity of what we were doing. So we could list the facts of what makes journalists trustworthy, like these are our policies, here's how we fact check things, here's how we correct errors, there's the facts of that. But if people don't believe in the more emotional side of trust, if people don't think journalists are on the side of good, if they don't believe that what we do is a public service, then the rest of it doesn't really matter. So let me just share first that there is a common misconception that trust in journalism is a Trump-era problem. It is not. Trust in journalism peaked in the late 70s, a few years after Watergate, and has been dipping ever since. The first big dip came during the 80s, the talk radio era. Rush Limbaugh did not do a lot of favors to trust in journalism. Then we hit the cable news era. Then we hit the digital era and the internet. So the problem really is one of bifurcation. The problem is one of people being able to get news that suits their worldview. And the easier it becomes to do that, the harder it is to know what to trust. So my team and I coach journalists in how to demonstrate that their work is credible, how to actively work to earn trust day to day rather than expecting it, and also in how to empathize with how hard it is to be a news consumer these days. So we see ourselves as standing in the gap of trust between the journalists and the public. I'm sure that you guys have all been in the position of seeing something in your inbox, hearing something from a friend, seeing something in your news feed and saying, I have no idea if that's true, right? I get a lot of emails from friends saying, Joy, is this a credible news outlet? How do I know whether to trust this? It is very hard. One of the things we coach journalists to do is to have empathy for that, to have empathy for how hard it is to determine what is trustworthy. And instead of defending the whole industry, I'm not here to defend journalism. I'm here to say, if you are a responsible, mission-driven journalist, here's what you can do to tell the story of that work. The question of, we'll talk about ethics, the list of ethical principles that I think you might have in front of you. Every complaint about journalists, we could find examples of where it's true. They don't care about getting it right. They sensationalize things. They're dishonest about their agenda. It's all true of somebody. So the goal in my conversations is not to say you should trust journalism. The world needs journalists. It's to say, here is how you find what is responsible, ethical, mission-driven reporting and information and what is not. So we work with newsrooms that are willing to do something about that. And we train a couple thousand journalists a year in strategies designed to pull back the curtain on journalism and address head-on the challenges people face when they try to figure out what the heck is going on in their information ecosystems.
It seems to me that to you, the problem is not so much journalism itself, it's how they message to news consumers.
It is both.
But I want to drill a little bit into the deficits. Do you perceive some kind of structural deficits in
journalism?
how journalism is practiced?
Yeah, man. Lots of them. I mean, there are problems with the success metrics in journalism. There are problems with how the business model of journalism incentivizes journalists to sensationalize things, to oversimplify things. Journalism contributes to polarization by quoting extreme views rather than reflecting the nuance and complexity of topics. Journalists themselves don't reflect the communities they serve. They're definitely whiter than the communities they serve. They're also mostly live in big cities. They're mostly higher socioeconomic class, more educated. They're mostly more liberal. And these are things that cause journalists to see the world. We all see the world through a lens of our own values and experiences. And one structural deficit of newsrooms is losing touch a bit. Newsrooms used to have a lot more working class people. They used to have a lot more military veterans. They used to have a lot more factors that gave them more things in common with their community. So one of the deficits I see is that journalists lose touch with who they're reaching and who they're not reaching, who feels served by journalism and understood by journalism, and who feels misunderstood or misrepresented by journalism. So the problem is both. The problem is that people don't understand journalism, and the problem is that there are things journalists are doing that they're not being aware enough about.
Can I ask you a quick question? When you first started, you had mentioned this point about almost living in our own filter bubbles, selective attention. How do you try to break through that? I think that's a big issue, right? Yeah. If we're conservative, we're going to go to Fox News. If we're liberal, we're going to MSNBC, whatever it is. How do you? What's your strategy when you talk to people for that?
Yeah, there's a lot that newsrooms could be doing to help people navigate the news. Most people don't understand that what they see is the result of a filter. My mom posted something on Facebook this weekend that was like one of those messages that was, I do not give Facebook permission to use my photos, right? And all of her friends weigh in and say, that's a hoax, that's not a real thing. People do not understand the extent to which what they see is determined by what they've already clicked on, what their friends are clicking on, the profile that algorithms have of them. There's a lot that journalists could be doing to help people understand. You're only seeing this. You might be missing this. There are newsletters I subscribe to and really appreciate that do things like, here's what this one issue today looks like. There's one called Tangle News that I just love, where a journalist says, here's what the right is saying about this issue, here's what the left is saying about this issue, and here's what I think. And my kid, who sees the world really differently than I do, my 20-year-old, we read it together sometimes. And he'll say, well, I think he's doing a good job here, but I don't agree with what he says. But he reflects the best version of different arguments. He, in good faith, shares how reasonable people on multiple sides of an issue see something. And I think that's too often missing.
Thank you for that question, Clay. Let's wade into law. Defamation. This is a big issue. It has generated high-profile cases recently. Can you first walk us through what mines usually are stepped on by news organizations?
Okay, sure. So defamation law, to start with, we know is about compensating individuals for harm to their reputation that are caused by false factual assertions. That's essentially what it's about. So in any kind of defamation case, we're balancing free speech interests, free press interests against the right of an individual to try to seek monetary damages for harm to their reputation. So landmines, really, in terms of what subject areas tend to get journalists in trouble, are imputing to someone criminal conduct. That's one hot area. Two, attacking someone in their occupation and profession, imputing to them some kind of lack of integrity. Traditionally, we had other areas, too, that sexual promiscuity, another danger area, saying that someone's sexually promiscuous when they're not, that they have some kind of a loathsome disease that they don't. In terms of things that you might think about in terms of sourcing, relying on credible sources, have you vetted your sources? I think that's very important, right? And that's in the SPJ code you have in front of you, right, about verify information that we have. So it's a huge area. As you mentioned, there are a couple huge lawsuits that have just come down, and one that you mentioned is E. Jean Carroll's. She's actually now successfully won 2 different defamation actions against the former president, Donald Trump. As you may recall, and you're probably familiar with this, was she said that she was sexually assaulted, and a jury indeed found that she wasn't raped, but she was sexually assaulted, right, at Bergdorf Goodman's sometime in the 1990s. And then what Trump did was essentially, after she said that, Trump basically says, "You're a liar, it's not true." And basically, it's what we call this area of liar libel, right? It's a whole area when basically he comes back and says, "No, you're lying, that's fake, I don't even know who you are." And then what does she do? Then she sues him for defamation, right? And so there are 2 different lawsuits, and she won a $5 million verdict, I think in May 2023 against Trump. And then what happens? Then Trump, of course, goes right out and basically repeats the same thing, which gives rise to the second suit. And then in January, the jury awarded, in that case, $83.3 million to Carroll in that one. And Trump just posted bond. You might have seen that on Friday, right? Of more than $93 million designed to cover the interest while he appeals that. So he's appealing that case. So those are 2 big ones, and again, of course, Trump will keep appealing these as long as he can and drag it out as long as he can. The other one that you mentioned was the Dominion voting systems versus Fox News and Fox News Corp, the parent of that, and that stems from the allegations by individuals such as Lou Dobbs on the air, Maria Bartiromo, and several other Fox News hosts that Dominion voting systems somehow had fraud, right, that they rigged the election for Biden and against Trump. So Dominion voting systems, you may have heard this, settled this lawsuit for a massive amount of money, $787.5 million, right, against Fox. I think Fox would have been highly embarrassed, as you probably saw. Remember the emails came out from Tucker Carlson, right, basically saying this is nonsense. Why do we have this going on? And other personalities, even Laura Ingraham, I don't know why I said even, but she basically said, this is all nonsense. Why are we doing this? And so I think settling that case, although now there's another lawsuit, Smartmatic, the other voting tech company, is out there, and they're seeking 3 times that amount. So when you establish and settle a case for a huge amount, Smartmatic is sitting there saying, okay, now you've given us something that we can really shoot for in this case. But I think the big picture was it saved the Murdoch family a lot of embarrassment rather than having to go through a trial where you would have put on Tucker Carlson, who obviously left Fox, right, and it wouldn't have been good for them. So it's a huge area, multiple lawsuits coming down all the time. I was telling Jim, and I'll stop here for a second, but about 12 or 14 years ago, we probably both attended it, there was a we go to this thing in New York called the Communications Law Institute every November, and they had a panel called "Is Libel Dead?" And it's definitely not dead. It's alive and hopping. A lot of social media get people in trouble too because somehow they believe they're not going to get in trouble for posting on social media. So,
thank you, Jim. Let's go to Florida.
Sure.
We're actually here.
Yes.
So, first of all, could you quickly maybe comment on the defamation bill that did not pass in this session of the legislature before we move to a high-profile Florida defamation case?
Sure, and I'll just spend just a minute on it since it wasn't passed. We don't really need to worry about this change in the law, but there has been for the last 2 legislative sessions an effort primarily driven by one panhandle lawmaker from Pensacola, but also with some support in other parts of the state to borrow a phrase from President Trump, loosen up libel laws or make it a little easier for people who are bringing libel lawsuits to prevail. And there were 6 different elements to this bill, so again, none of them passed, so we don't need to worry about them too much, but to give you an example of one provision would have said that actual malice, which is the mental state requirement that's necessary for a public figure or public official to win a defamation case, the plaintiff would need to show that the journalist doubted the truth of what he reported, seriously doubted it. So look inside that journalist's head, jury, and decide, did the journalist think he was lying, basically, is the standard. This law would have had judges assume and tell juries to assume that the reporter in fact doubted the truth of what the reporter was saying if the reporter relied on an anonymous source. And so the argument we were making, of course, is that a lot of journalism starts with an anonymous source. Now, rarely will it end there, typically, and Joy certainly can talk about her research in the field. I suspect there are very few journalists who would just say, oh, something just showed up on an anonymous phone call, I'm going to go with it and put it in the newspaper. That is not the way journalism's done, but the thought behind the legislation was, well, we need to assume that if there was an anonymous source anywhere in the process, that the journalist was lying. And fortunately, that wasn't enacted.
So we should probably worry about this law coming back,
Yep.
given its history. So keep your eyes open about the Florida defamation law in the next legislative session. Jim, there is one case, actually 2 cases in Florida that are about defamation, and it's actually quite important for media. Could you explain what this case is about?
A lot of examples we could have brought. I picked out one in particular just because I thought it was interesting, and Sarasota being a golfing community, some of you may be familiar with the players. Golfers in the room, a few people who play a little bit. Anyway, Patrick Reed, very well-known golfer a few years ago, was among the early early PGA Tour members to be interested in Live Golf. Everybody know what LIV golf is, Live Golf. Sponsored by a fund that was affiliated with the Saudi Arabian government, and took a lot of criticism at the time, he and many others, over their, not necessarily to use a pejorative term, but we might get this appropriate, defection from the PGA Tour to join this alternative tour. And I wanted to use this as an example because it gets to one of the things that would go to one of the elements Clay mentioned, and that is that defamation is supposed to be about false statements of fact. A fact that Patrick Reed cheats at golf, that on this day he deliberately forged his scorecard. That's a false statement of fact. And there were some allegations that I won't go into about Patrick Reed's behavior on the course, but one of the claims in the case was not so much about Patrick Reed, things he did on the golf course, but about his affiliation with Live Golf. And forgive me, my reading glasses just broke, so I'm going to have to hold them this way, but I think I can make them out. So anyway, this is a blogger, a podcaster, he's also a blogger, but a podcaster named Brandel Chambly, talking about Patrick Reed's interest in the Saudi Live Tour. So if they talking about Patrick Reed and other golfers. So if they've aligned themselves with a tyrannical, murderous leader, if you look at who Mohammed bin Salman is, who was the head of Saudi Arabia at the time, centralizing power, committing all these atrocities, look at what he's doing to the citizens of his country. Ask yourself, would you have played for Stalin? Would you have played for Hitler? Would you have played for Mao? Would you have played for Pol Pot? Would you have played for Putin? And this is who this guy is. He settles disputes with bone saws. So that's a commentary on a podcast about the lawyers who are the golfers who are defecting from the PGA Tour and joining Live Golf. This is among 50 statements that are cited in 2 lawsuits that are brought against Chamblee and many other members of the news media, case brought up in Florida. And the judge takes a look in a very thorough opinion, goes through all 50 statements, and I'll just mention the analysis of one here, and that is, are those statements of fact? Is anybody saying, is the podcaster really saying that, in fact, Patrick Reed is aligned with some of the things that the Saudi government does to its own citizens? Not literally, right? He's not literally saying this golfer thinks it's okay to go after people based on their sexual preferences, or for example. What he's saying is, look, he's getting hooked up with this golf tour that's funded by the Saudi government. And anybody who's listening to the podcast is going to understand that. So that, the judge says, is a matter of opinion, not a fact, or it's what we lawyers like to call, because we sometimes billboy the word, rhetorical hyperbole. Anybody know what rhetorical hyperbole is? Yeah.
Explain.
Exaggeration, wordplay. It's something that would not be taken literally. Everyone knows it's an obscenity someone might utter. You're not saying a literal fact, and anybody listening to that podcast would have understood it. So that defamation claim, the claim on that statement wasn't allowed to go forward. None of the others were allowed to go forward. Patrick Reed's lawyer is appealing. We'll see what our appeals court wants to do with it. But that's an example of how we might say there was a false statement, but was it a false statement of fact? No. Case should be dismissed, and this one was.
That's one of those statements that we would make on those airwaves in our station, so we could be liable. Where's that case now? You said it's under appeal.
Yes.
The first instance was against Reed, and
Right. So a judge up in Jacksonville dismissed the case,
Okay.
and it's in federal court. And so the way that happens is there's a federal appeals court. The judges mostly are in Atlanta, although some are in other cities, and they will at some point get briefs from the media lawyers. They've already gotten the briefs from Patrick Reed's lawyers. There'll be an oral argument probably sometime this summer or in the fall to decide whether the appeal should be denied, in which case the case would really be over, or should it go back down for the trial judge to do more work.
all right, thank you.
Can I
Go ahead.
Well, I was just going to say, how much does it affect that it was on a podcast? Isn't that sometimes relevant that we know, like somebody mentioned Rush Limbaugh, but, we kind of say that's going to be a rhetorical hyperbole, right, on a podcast versus a newspaper. Does that play in here?
Yeah, absolutely. Clay, as you know, there are typically 3 categories of information that a court might look at in deciding whether something's opinion. It's the context, it's the genre, so the broader category that the speech is in, and just whether the language is verifiable. And so I think you're absolutely right. The first thing we might think is a podcast, that category of speech, lends itself to loose figurative expression, and that's going to weigh against this being a statement of fact, more likely to be seen as an opinion.
My question to both lawyers here, we are producing news and opinion on WSLR with beginners and amateurs. Should we be doing that?
Well, certainly as a First Amendment advocate, I say yes. And I think it's good to have sessions like this to help those speakers understand and think about the issues, because there are risks, and as Clay says, more so than 10 years ago. Certainly we're seeing a lot more litigation. And so, sure, there are things we want to think about. There are things that are risky in turning over a microphone to folks who maybe haven't had to think about the legal issues.
could you move closer to the microphone, please?
Sure.
It's important for everyone to hear what you're saying. Thank you.
Can I just add that it's on purpose that you don't need any sort of certification to be a journalist? That's on purpose. When I worked at the Herald Tribune, we did a little informal poll, and I think there were 150 people in the newsroom at that time, and half of us had been to journalism school. And you could go to journalism school and learn really different things. I talk to journalists all the time who went to journalism school, and I'm like, how could you not realize that's a bad thing to do? So, we're all picking it up as we go.
All right. We don't have to be certified. Joy, kind of picking up on that, journalism ethics, we are a community journalist-based news organization. As I said, we're working with beginners, we're working with amateurs, we are working with people who are embedded in their communities. You have the Society of Professional Journalists Code of Ethics on your table, and one of them mentions conflict of interest. So what about if I'm reporting about my own neighborhood? What kind of recommendations would you give to a news organization like ours?
So the most important thing when it comes to matters of ethics is transparency. Are you clear about where you're coming from? This is true whether your connection to something is that you live in the neighborhood. It's true whether your connection is that you have strong opinions about something. There's a lot of journalism done by people who are advocating for an issue or who are doing journalism through a specific lens. And that's perfectly fine in my view as long as they're clear about that and they're not hiding it. And that is actually key to public trust. People say, I don't mind getting my news from Christian talk radio because I know where they're coming from. I don't mind getting my news all from Rachel Maddow because I know where she's coming from. So the question of how close we are to issues is really such an interesting era in this world of more professionalized journalism. I've spent time with people reporting in very small communities. I followed a community newspaper editor around a very small town in Missouri and watched as he showed me that he lives on the town square. He showed me that when he shows up to cover a car crash, he probably knows the people involved in it. He showed me that he was, as a community leader, on the volunteer board that selected the architect for the new school that was being built. The relationship between journalists and the communities they serve is something that evolves and that is also very contextual in terms of what's appropriate. I think the important thing is for us to be very self-aware. Are we able? We all see the world through a specific lens. Are we able to acknowledge that either publicly with our audience or with our colleagues and say, can you check me on this? Because I think I might be missing something. The danger is high that I might be missing something because I'm very close to it. So it might be that you're so close to something that you really should have a colleague report on it. And I certainly, in every newsroom I've been in, there are certain things where an editor will say, oh, we're reporting on this business where my wife works. So somebody else is just going to have to edit that story. And other times it might be, I'm very involved in this neighborhood effort, so I can't be the one to report about. I can't use them as an example of trying to get speed bumps in a neighborhood because I live there and I've been involved in it. And other times, you disclose it to the audience and say, there's this connection. The newsroom, journalism is often a team effort, and we talked about it amongst ourselves. And I relied on my colleagues to make sure that I was handling something fairly.
Thank you, Joy. Very recommendable lecture, The Code of Ethics of the Society of Professional Journalists. Keep it and read it. It's really worthwhile. All right, let's move to another hot topic here, artificial intelligence. Clay, you have worked with artificial intelligence, and you have actually compared different news organizations' approaches to artificial intelligence. Could you tell us what news organizations are and are not doing at this point?
Sure. So what I did was I looked at the different policies of a number of different organizations like the Associated Press, NPR, Wired, for instance, RTDNA, Radio Television Digital News Association, and Gannett, the USA Today network, and tried to look at their policies because obviously journalism is in trouble, and some people foresee that generative AI, ChatGPT-4, whatever it is, Bard, will be able to reduce costs, right? And so, it might be able to take a box score in a baseball game and figure out and do a pretty decent story, basically. Somebody got a single, somebody got a home run. It could take a stock ticker and say the Dow closed up this, and it has a formula to it. But obviously, as we know, and I like the euphemism that they use, hallucinations, everybody heard that, that it will hallucinate, it will produce false information. So what I did was I kind of looked at these different policies, and I'll just go through them in terms of what journalistic concerns are right now about using things like ChatGPT and generative artificial intelligence in reporting, and then how they're dealing with them. So the biggest concern is accuracy, and obviously that's one of the 4 SPJ principles that we have, accuracy and fairness in that first principle in front of you of truth-telling, right? And so because it does and is known to produce false information that it calls hallucinations, or like those in the industry like to call it, that's obviously something that journalists are very worried about. That it's going to miss context and viewpoints and angles that journalists have to think about. We don't know all of the information in the data sets that are fed into things like ChatGPT, the large language models. We don't know who the sources are, right? And so it's up to a journalist ultimately to say, okay, whose view are we missing, right? You were talking about journalists predominantly white, maybe upper class, right? Whose views are we missing? Because one of the principles from the SPJ is also give voice to the voiceless, right? And so somebody needs to be able to look at all the different angles out there. Biases, too, right? That this is another danger with large language models and generative artificial intelligence. They're created by humans, and those humans have biases, right? And so whatever they code in may actually exacerbate those biases, and journalists have to be on the lookout for those. Other ones are plagiarism, right? This is part of the New York Times' lawsuit right now. That and obviously there's an argument that the Times tried to coax out of ChatGPT certain information. But nonetheless, this notion that it's actually plagiarizing somebody else's copyrighted material, and that's a really serious issue, right? That these devices are fed on copyrighted material. Associated Press has a licensing agreement, right? They've got a licensing agreement, and frankly, I think they're going to make billions out of this. They should all give licensing agreements to journalists, right? Because they're using their content to being fed it. That's my little sidelight. But anyway, plagiarism. Other thing, too, is dull, unoriginal writing. The writing that comes out is very formulaic. It's dull. It's not original. And essentially, journalists know what facts are most relevant for their audience, which are least relevant, how to tell the story in an entertaining manner that will attract their readers' attention. So journalists are concerned about that. They're also concerned about the audience's trust, right? And so to go back trusting, we don't really know enough. Is the audience going to actually say, oh, I really trust ChatGPT to put out the news story, instead of the journalist that I know who does live down the street or in the, somewhere in town, and everybody knows who that journalist is. That it lacks the human judgment to balance interests. So it'll produce and spew out information, but only a journalist can sit there and say, does the public's right to know that information outweigh the privacy concerns in that? And so only a journalist can really do that. So these are a number of different concerns that we have. So what are journalists doing right now in terms of their policies? The first thing they all say is they need to develop clear policies. Whatever the newsroom is, whatever the business is, they need to develop clear policies about how they're going to use it or not use it and what they're going to do. This is actually true for a couple of the policies I've read. They say to treat the output as if it were an unvetted source, and that's one of the things that I mentioned in terms of defamation law. Treat it as if it were an unvetted source, right? That you don't know who it is, or an off-the-record source is what somebody says, right? You want to get that, somebody, as Jim said, you're not going to go out there and say, we got an anonymous source. You're going to try to get confirmation, right, from that. And so that presumption that it's wrong, that it's off the record, it needs vetting, is, I think, very important that they're talking about. Some, Wired and the Associated Press, actually bar its use for creating publishable content to date, and Wired also for editing publishable content. They bar its use. Others require prior approval. You've got to talk to an editor, somebody up the chain, if you're going to use it in any way. So it's not just the journalist on the ground. You've got to go somebody above you, talk to her or whoever it is, and say, okay, why is it important that we use it in this? So putting another check into that thing. And then transparency and disclosure, right? So if you're going to use it to create a story or any part of that story, we're talking about transparency and disclosure on the fourth principle in the SPJ code down there. The public has a right to know that. Your audience has a right to know how you're using it. So what are they using it for? They're using it for brainstorming, suggesting potential story ideas, suggesting potential headlines. Some will actually use it suggesting for social media posts, the text for that. To look for patterns in data sets, right? Because it's going to be quicker on that. I can feed it all this information, and it can look for patterns. But again, those are just really for generating ideas, not actually for the publishable content. And again, the final point is that they try to treat it, the use of it, the same standards that the SPJ has in that code, the Big Four principles. Those would apply to any use of generative artificial intelligence. You'd have to run it through those same things. So that's kind of a big picture where we are right now. More like experiment. The New York Times, by the way, has already hired an editor for artificial intelligence, and his job is basically to have a staff to experiment with uses, right? They can experiment with it right now and figure out how best it will be used. So it's coming, but there's a lot of hesitancy and reluctance in terms of the particular uses.
Running the danger of appearing like a purist, I'm amazed that news organizations would even consider producing content through AI.
Oh, really?
Joy, what's your
That's so interesting.
What's your feedback to that?
Well, that New York Times, if we're talking about the same person, Zach Stewart at the New York Times, he wrote something recently about how a bunch of different newsrooms are using it. He was talking about the New York Times training a Gen AI model to search satellite imagery of Gaza and look for crater holes where bombs might have been dropped. So it's very, very good and effective. Not that they're going to then go say, hey, we know for sure there was a bomb here. But they can't possibly be continuously reviewing all the satellite imagery available in a war zone. So I think that that generative AI is a very, it's right to be cautious and nervous about that. But there are a lot of ways that we process large amounts of data that make us much more efficient and make us able to do the kind of journalism that wouldn't otherwise be done. You can take a large amount of data and say, summarize this for me in a timeline. You can ask something, man, the times I have spent as a reporter trying to understand things I don't understand. I talked to one journalist who said she'll ask ChatGPT, like, how does a wind turbine create electricity? And you're just looking for, you're not gonna publish the summary of what they say, but you're just looking to understand it more deeply so that you can ask better questions. My team has used ChatGPT to actually check for bias in a story. We've been experimenting with this. Upload a story and say, how would this story about this abortion ruling feel to people on different sides of the abortion issue? And it will flag language and say, this term is going to feel loaded to people who see it this way. This is going to signal that it was written with this lens in mind. That doesn't, and then the journalist gets to decide whether they do anything with that information, whether they change the language they're using. Of course, there's human touch at the end of it. But my team uses ChatGPT to brainstorm headlines sometimes. I'm looking for a title for a grant proposal, and I can put in my grant proposal and say, what should I call this? And it spits back words I have not thought of before that are catchier. I'm not that great at headlines. So there's a lot about that. Now, leaning into the human part of it, the New York Times just recently unveiled, they call them extended bylines, I think, and they're bios that just really emphasize from every reporter's bio, you can learn with one click a lot more about their credibility, how they see their work, their education level, that kind of thing. And they said in the explanation about it that one of the reasons they did that is they know that knowing who the humans are behind the journalism is only going to become increasingly important. So leaning into that kind of engagement and that kind of connection is also important. But I think there's a real danger in saying we can't touch anything that, that generative AI has helped produce is short-sighted.
Thank you for pushing back. So the last item we want to touch on here, we're running low on time, is Florida Sunshine Law. Open records, we live in one of the better states of the union, actually, when it comes to access to government documentation. But additional laws are chipping away at that right, and practices are chipping away at that right. Jim, could you lay out what's going on right now?
Sure. First thing I want to do, though, is say, because we're short on time, is recommend anybody who is planning to be a journalist in Florida should have this. This is the Government in the Sunshine Manual. It's published by the First Amendment Foundation. The 2024 edition just came out. I have order forms for it.
Hot off the presses.
Hot off the presses, and so I'd really encourage you to get this. And I'll give you the information to help you order one. I'll be glad to share it. But it does a great job of walking through the three pillars of open government in Florida. The first is our Constitution. Article 1, Section 24 of the Florida Constitution enshrines there the right of access to meetings and records. And then there are two statutes that flesh out that in detail. The first is, to be precise, the Sunshine Law, which deals with open meetings. That's your right of access to meetings. So if you want to use the jargon right, Sunshine Law means that the Sarasota County Commission has got to provide notice and allow people to attend its meetings, and I'll go through some of those details in a minute. But the other thing that we tend to deal with more as media lawyers helping clients in their news gathering is the Public Records Act, which is, as the name suggests, the law that says every government record, whether it's an electronic, piece of paper, whatever, you have a right to request the opportunity to inspect
Anybody
it
does,
and to
right?
copy it.
Not just a journalist.
No, just the people in this room. No, everybody does. That's right. Any person, and you don't need to be a citizen of Florida. You don't need to be a citizen of the United States. Any person has the right of access, the right to inspect any record at a reasonable time and under reasonable conditions. And, of course, there's a lot of argument about what that means. But getting back to the question that Johannes teed up, where things stand now, the Public Records Act originated in the 1970s. I wish I could tell you off the top of my head the number of exceptions to the Public Records Act at the time, but I'm sure it's got to be multiplied by 10, if not 50. Every year there are more exceptions being codified. We did not see some of the more troubling ones enacted this year, but there are more in the works, I'm sure. Every time the legislature gets together in January, we see a long docket of efforts to create more secrecy and to hide more information. And the good news is the procedures under the Public Records Act are still pretty strongly in favor of the requester. When the legislature wants to create a new exemption, the Constitution says the legislature has to explain why there's a public necessity for the exemption. It can't be any broader than it needs to be. And then even when one of those exemptions applies, if you've asked for a public official's personnel file, you have a right of access to that personnel file. There may be some things in it, like his or her social security number, that the agency can redact, black out before you're given the file, but you have a right to that file. And those exemptions, redactions, if you will, have to be applied narrowly. They have to be limited to what the exemption calls for. If you ask for data in a large enough quantity, the agency can charge you money for the work of gathering that data, but it has to charge a reasonable amount. It tries to charge you no more than it's actually costing to gather that information. And if there are people involved, it can charge you the hourly rate of the person who's doing the work, but it can't put the most expensive person in the building on the job. It's got to be the lowest hourly rate applicable to a person who's capable of doing that work. So that is a very quick discussion of this entire book. Maybe I'll wait and answer questions on the details of how the Public Records Act operates, but that's a quick introduction to that.
Thank you. So now it's your turn. We have a microphone right next to the stage over there. If you have a question, if you have a comment, a suggestion, please tell us now. Speak into the microphone. This is being recorded, so if you don't speak into the microphone, the afterworld will not be able to understand what we're saying here. Go ahead.
So I'm not familiar with the book that you held up, but isn't the official Government in the Sunshine Manual available online for free as a PDF?
That's a great question. I don't know the answer to that.
I think it is, and I downloaded it, and it's big, but what's great is it's searchable. So because it's PDF, you can put in keywords, and I found it very useful. It's confusing, and there's a lot of nuance in it, but it cites specific examples in different cases where, and then you get the Attorney General's opinion or whatever. So I found that useful.
It's a basic tool for reporting, really, in this state. So very helpful to have this resource. Go ahead.
I got a question. What kind of exposure can a station such as WSLR end up with when they go down this kind of path of anonymous reporting or accidental reporting, or what's basically slander, or associating? I mean, it's the oldest fallacy in the book, associating something good with something bad that you'll think of in the voter box or whatever. But how much exposure is there for WSLR, seriously?
I mean,
are there any previous cases where a small organization like this has gotten in bad trouble?
Okay, so the first part you mentioned slander versus libel. So typically slander is spoken, but most states, including Florida, I think, would hold that radio and television are actually libel on the libel side. So that's the typical division. So defamation law, libel printed, slander spoken, but in radio and television tends to fall on the libel side. The same liability exposure wouldn't make a difference, I don't believe, in terms of the rules that would apply. I mean, correct me if I'm wrong, the same standards would apply. Obviously, the potential for bankruptcy or going out of business is something that any news media entity has to worry about today. That's a legitimate fear.
Yeah, I think that's exactly right. In theory, the damages in a defamation case should be proportionate to the harm that's caused. So a radio station that reaches 10-mile radius maybe wouldn't cause as much damage as the former president of the United States and his commentary that Clay's already mentioned led to, $83 million judgment. However, things are on the internet, right? Things live on, and the cost of defending a case like this can, even if the damages are going to be small, can be significant. So a station like this would need to think about that as well. I mean, often media companies have insurance that will cover the costs of defense and some portion of the liability, but that can all be a significant burden. And then I would just say, as a practical matter, I'm sure your journalists want to be doing journalism. They don't want to be defending journalism they did in the past. And I certainly think, as a media lawyer, part of my job is to try to minimize the distractions for my clients, help them do what they want to be doing, the journalism. And libel litigation doesn't really allow you to do that. You're going to have to look back and dig in your notes and explain why you said what you said and think about why you did what you did. And so that's a cost for sure. And that would be true here as well as a big news organization.
Can you maybe talk, while you're at that, about pre-publication review in terms of what that entails in order to, before the lawsuit exists? What would you do if somebody says, here's a touchy story we might have, and they bring it into you? What would you look for? How would you?
Yeah, that's a good question. I mean, part of my practice.
Thanks, Jim. I thought of that. No.
I will be glad to talk about myself. Thank you. Part of my practice is reviewing stories for folks before they go on the air or into print or onto the internet. And so, if a story comes in, I'm immediately looking through it for, okay, who are we mentioning here? In lawyer jargon, it's who is the potential plaintiff, who is someone who might be suing over this, and then what are we saying about this person, and why are we saying it, and how do we know that it's true, and where did we get the information? One of the biggest tools for journalists, I think, should be public records, because in Florida and in just about every state, I think, if we fairly and accurately report something that comes out of a government document, whether it's a police report or a court file, we have a privilege to report that. That means we're protected from liability in most circumstances. Like anything in the law, it's not absolute. But basically, if we know that the police have arrested somebody and charged him or her with a particular crime, we can report what the police are alleging, and our reporting is protected, even if that person's not guilty. So, and likewise, we can go down to the courthouse and get a civil complaint. If the case has been around long enough, maybe there's an answer. And so we might want to say, Joy has sued Clay, Joy alleges this, Clay denies the allegations. That's a fair and accurate report, that's privileged. So those are ways to protect yourself.
Could you please state your name?
Hey, I'm Kathy Antunes, and I host a program here on WSLR. And you may know in our community, I'm not sure who this question, maybe Joy, there's a pattern with elected officials in Sarasota and mainly at the county level, not making themselves available for debates, refusing to talk to certain journalists like me. But I'm curious to know, what does a journalist owe an official who doesn't want to make themselves available in terms of public trust? And, my experience is they just don't want to answer questions that aren't, have bad facts for them.
Yeah, I'll take a stab at that. It's great to meet you, actually.
Oh,
I'm a
thanks.
longtime fan. I'm going to push back on your question.
Okay.
Because I don't think the question is, what do journalists owe the public officials? The public officials work for the public.
Well, yeah.
I think the question is, what do journalists owe the public?
Okay.
So if the goal is a more informed citizenry, if the goal is to equip people to make decisions about public life, about their tax dollars, about who they elect, then the question is, how do you inform the public? So one element of information that the public needs is which public officials are willing to be held accountable. One element is, what else do we know? How can we share what we know about this person's background and what they would likely say if we could interview them? How do we continually remind people who is playing nicely and who is not? Knowing, of course, that for some people, the anti-media bias is the point. For some people, buying into the fact that, of course, why would somebody talk to journalists? They're just going to they're just going to skew it. They're just going to get it wrong. They're just going to make us look bad for fun. Realizing that when you say so-and-so wouldn't be available for wouldn't make themselves available for comment, some people are going to cheer and think, yeah, right on. Don't talk to those journalists, right? But there are a lot of things journalists can do to investigate that person's public record, to run white space. If you have a voter's guide and somebody says, here's this person responded to us and gave us these answers, this person did not. Here's where you can see what they've said before, but here's the blank space. Okay. There's a lot you can do to interview people around that person, I think, but with beating a continual drumbeat that you work to be fair, because here's the problem. The public does not believe that you're working to be fair. The public does not believe. When people don't understand how something works about lawyers, about journalists, they don't usually give each other the benefit of the doubt. If they don't understand what we're doing, they assume the worst. So if they see a story with one side of the aisle with a Democrat quoted and a Republican not quoted, their assumption is going to be, well, you just want to draw attention to the Democrat, right? Mm-hmm. And so the effort we make to be fair, we need to spend much more time talking about. I've done some work with PolitiFact in St. Petersburg, and they have a whole section of their website that says, we fact check across the aisle, here's where you can find evidence of that. Here's how we decide. Here are the principles that drive our work. So I think if you are routinely featuring stories that are more one-sided than you wish, then figuring out what it is, what the public might assume about that, what your counter narrative is, how you want to explain why, of course, you wish, why you gave them many chances. There are also journalists. Remember, every complaint somebody has about journalists, we can find examples where it's true. There are journalists who would call somebody 10 minutes before publication and then put in the story they were unavailable for comment when they gave them 10 minutes to reply, right? So no, if you have made a continuous effort to allow someone to get on the record in ways that are convenient for them and they are ignoring you, then explain that. Don't just say they weren't available. They didn't return phone calls. Say we've called, we've gone to the office, whatever it is, 5 times. They're not talking to us.
Can I ask a follow-up question?
Go ahead.
This actually happened to me. If you have a candidate in an interview, it's a live radio show when I'm in the studio.
I'm so glad I've never been live. Bless you. I would be terrible at live.
It can be. I had one guy confess to election fraud on the air, so that was kind of cool. But anyway, and so that was one thing. But I had a candidate with me who was actually getting text messages in response to my questions, and I realized it well through, and I was kind of so shocked that I didn't know what to do.
So somebody was answering for him?
Yeah,
like,
well, I mean, she was. I'd ask the question, and it's not a big delay, so that she would get a message about what to
prompting,
say.
Yeah.
Mm-hmm.
Wow. Did you? I mean, I'm sure that would be a lot to try to figure out how to respond to in the moment. I would love it if you had said, "Hey, what's your message there?"
I'm just ethically in terms of trust. I guess I could.
The challenge is that you don't want to score points at the cost of your credibility.
Right.
Like you don't want to do it in a way that is
it's
sort
like
of
a
gotcha.
Bad gotcha. Right.
Right. But you can say, I don't know. What would I say? That's a really good question. I think I could say, I'm really hoping. I wonder if you'd be willing to put your phone away, because I'm really hoping to just hear what you have to think about this and not have you looking things up in the middle of the interview.
Thanks.
Yeah. Thank you. Anyone else?
Arlene Sweeting. Dr. Calvert, I'd like you to comment on a couple of things. One is government regulation of social media platforms, which we had a number of discussion about on the Florida legislature this year, and also government intrusion into academic freedom.
Sure. So social media platforms right now, the United States Supreme Court has two big cases in front of it. One involves Florida. It's called Moody versus NetChoice. NetChoice is a trade association for all the Facebooks, X's of the world. And the other is out of Texas, and that is called NetChoice versus Paxton. And it's ironic because it's efforts by red states to regulate businesses and how they operate. Both laws were adopted, obviously, after Trump was deplatformed from January 6, 2021. So Florida's law essentially bans the deplatforming of candidates, legally qualified candidates for state or local office here in the Sunshine State. You cannot deplatform them, which means they could violate the terms of service and terms of use and post content that is not acceptable as many times as they want, and you can't throw them off. That's one aspect of it. Also, it deals with journalistic enterprises. So a social media platform, and by the way, Florida's law only applies to those with 100 million users or 100 million in annual revenue is what it is. So it's only the biggest platforms, which is another problem with it because it's kind of speaker-based discrimination. We're only going to go after these large ones, and there's a reason, obviously, why that was, because it's really Facebook and now X. So that's very problematic because essentially you are co-opting their exercise of editorial control and discretion. We had the case here in Florida in 1974, Miami Herald versus Tornillo, right? And that case, the Supreme Court struck down a Florida statute that said that candidates had to be given free of charge the right of reply space in a newspaper if they were criticized. By the Miami Herald criticized Pat Tornillo, and he had to be given free space in the Miami Herald, same location, free of charge. And the Miami Herald said that interferes with our ability to exercise our own editorial control and discretion. And the Supreme Court said, you're right. The First Amendment right, freedom of the press, you get to decide, not the government, which goes into your newspaper. And the social media platforms, NetChoice, the trade association, is arguing that same principle applies online to speech communities. These are private businesses like Reddit. Maybe some people have Reddit. They go into a sub-community. They create their own communities within that, and they enforce their own different standards within that. Imagine that were stripped away from you. I'm sounding like I'm arguing for NetChoice. But imagine...
You should be. I filed a brief for NetChoice, so go ahead.
Yeah. So what? Now I'll just flip it over and finish this one off. But what the states are arguing, what Florida and Texas are arguing, is that the platforms are nothing more than common carriers. This is their big game-changing argument, that they are simply message-transporting businesses like FedEx or UPS or the telephone company or telegraph companies. And so if they fall into the category of common carriers, which they are not, but if they do fall into that, that means you cannot discriminate, right, against any speech. So FedEx can't say, I'm not going to deliver. That's the easiest example. They are a common carrier. I'm not going to deliver your package because I don't like the Republican or the Democratic content in that box that you're shipping to somebody. So it would totally destroy the platforms, as we know them, were the court to uphold Florida and Texas's laws. I don't think they will. Clarence Thomas has an appetite for saying that they are like common carriers, but I don't think the majority is there. So in terms of Florida's own more recent legislation, remember the one about minors, right? And so this was the one where initially was going to ban anyone under 16. So 15 years of age or younger, you could not be an account holder on a social media platform. And then we kind of that didn't, even DeSantis didn't like that. And then, so they created this said, well, if you're 15 or 14, you can get your parents' permission, right? This is, I think, where we are now, right? If you're 15 or 14, you can go on it as long as you got your parents' permission. If you're 13 or under, then you can't at all. As I wrote somewhere else, I said, this is burning the house to roast the pig, or another one, throwing the baby out with the bathwater. Social media platforms have some tangible benefits for minors, right? They can connect with others, they can socialize, they can meet people, especially LGBTQ type of communities where they can find other people like themselves and talk to them. So there might be a lot of negative, but to totally ban access, right, instead of finding other ways of trying to thread that needle, is highly problematic. Academic freedom was the other point on this one. We just saw, you probably read about it today, that in the grade school areas on the Don't Say Gay bill, they reached a settlement, right? A proposed settlement was negotiated. Both sides claim victory on this. about things that you can say and cannot say in the classroom. Academic freedom is, I would say this, it is not a well-established right. We talk a lot about it in academia, academic freedom, but the doctrine of academic freedom is simply really not very strong. The Supreme Court has a lot of great statements, rhetorical hyperbole, right? Where they say, like, the marketplace of ideas in public universities, and they will go on. What really comes out for most academics is public employee speech rights. So if you're at a public university, any state system in Florida, then you're going to go through a public employee speech analysis, which is how you would look at any case, right? And you would really ask two questions. Are you speaking in your private capacity or pursuant to your official job duties? And two, are you speaking about a matter of public concern or a matter of private concern? You're going to have the most First Amendment speech rights if you're speaking as a private citizen on your own time, off campus, and you're speaking about a matter of public concern. The Supreme Court of the United States left a caveat in a decision called Garcetti versus Ceballos in 2006. Gil Garcetti, the former prosecutor in Los Angeles. And they said that first notion, remember the first step is, are you speaking pursuant to your official job duties or as a private citizen? Well, as a teacher in the classroom, I'm speaking pursuant to my official job duties, aren't I? And under that analysis, I would have no First Amendment rights, is what the court basically said. But it said in Garcetti, it dealt with an ADA, not an academic setting. We're not going to answer that question because we don't have that facts before us. So it's been left to lower courts to kind of recognize that there probably is, for classroom teaching and academic scholarship, there will be more rights in that situation. If you're in the classroom, but I can't, if I'm teaching a First Amendment law class, I tell people I can't teach Shakespeare. I'd like to, but I can't do that. That's not my academic freedom to do that. So academic freedom is a perilous right. It's not a very strong doctrine. I probably said too much on that, but it's more public employee speech rights. Just how you would analyze a case, I think.
I think that's right. Yeah, just to add one bit of good news, I think on the net choice front, it's very perilous to try to predict outcomes based on oral argument. But the argument was at the end of February in the two cases Clay mentioned, and Justice Kavanaugh was very outspoken on this idea of the speaker being a private platform like Facebook, a private company. Its First Amendment rights are at stake. We're not just focused on the commenter's First Amendment rights. And of course, the commenter can go create another platform. And I think the irony, or send email, or add a newspaper, or whatever, go through a commenter who's kicked off a platform. And I think the irony of this, or maybe the great example of this, is this litigation, as you said, Clay, these laws started because Donald Trump was kicked off Twitter. Donald Trump doesn't use Twitter anymore. He's allowed back on it, and he doesn't care because he created his own platform. So that sort of proved why we don't need these laws, at least in that instance that seemed to drive the Florida lawmakers.
Yeah, and if I could just add on that too, you're absolutely right. I mean, the strongest offenders on that during the oral argument were really Kavanaugh and Roberts, right? And so they're going to hold, as they tend to now, they hold the center. If you really kind of divide the court, in many cases, they're especially Roberts, but Kavanaugh has actually come around, I think, in a lot of different cases. In that, if anybody's going to rule against the social media platforms, it's going to be Thomas, and maybe pulling Alito in. With him. But actually, Amy Coney Barrett asked a really good question, and her question was this. Okay, so you saying in Florida you can tell a bookstore where to stock books on its shelves and which books it has to stock and where they're located, and Whitaker, the Solicitor General for Florida, he dodged that. So let me back to another question you had, because I read over the transcript and you never went there on that one. But if you just imagine, that's the same thing, right? You couldn't go in, if we still had many bookstores, but we do have a few, you can't go in and say, okay, well, the state of Florida thinks it's best that you stock these books and you put them right here on this shelf, and the other ones you don't stock, and those you do stock, put them in the back. Because that's basically what these laws do. They tell them how to curate content, where to arrange it, and where to place it. Who was your brief on behalf of?
Electronic Frontier Foundation.
EFF. Yeah. Okay.
But the one other quick point on this one, and then I know we need to move on. But I love the Kavanaugh on the subject, especially because just a few years ago, in a case out of New York involving a public access TV station, sorry, not a radio station, but he picked up something from Benjamin Franklin, who said a newspaper is not a stagecoach. It doesn't have to be made available to all comers. And so I think it's going to be very unlikely that, I guess it's actually 7 years ago, I think it was a 2017 opinion. Yeah, that he's really now going to say, well, I'm not going to do that. What I wonder is there going to be some off-ramp, whether it's because of some issue short of the First Amendment, that the court decides we're not going to issue a broad, stirring pro-First Amendment opinion in favor of the platforms. There are some differences between the Texas law and the Florida law, so it's possible that there'll be some more litigation on this front, and especially in the Florida case. We'll have to see what happens come probably, mid-June, I think, by the time we get an opinion.
And we're getting really law nerdy here.
Thank you, sir. I'm sorry.
But Roberts loves judicial minimalism, right? Roberts loves minimalistic decisions, so you're right.
Thank you, sir, for waiting patiently. Please state your name.
Hi, I'm Richard Resigno, and I worked at Barron's for about 40 years. Barron's is an investment and financial publication, a sister publication of the Wall Street Journal. Now, we were sued all the time because of the nature of the material we dealt with. We'd say, we tell people, this stock looks good, this stock looks terrible. Management, these people are incompetent, they're crooks, this is a fake company. So I would say we had maybe 24 lawsuits in my stretch. One we settled, and that was because it was a ridiculous suit. It involved Frank Sinatra's lawyer, who, for some reason, somebody in our staff called Frank Sinatra's mouthpiece the lawyer-preferred spokesman. So, I don't know, I think we gave him $500 or something. The other one was very serious, which was a guy in Australia who had a very complicated financial scheme. He was laundering money through some rabbis in Brooklyn, and it was a real controversial case. However, in Australia, they had a 19th century law where you really couldn't defend yourself, so we lost that case. I think that law has been taken off the books now, and actually the same guy went to jail for laundering money a year later. But my point is this. What you were talking about with artificial intelligence has been going on for years in a different guise. We would always have a rule that you had to have 3 editors look at a story. And we also had fact checkers. So things were pretty filtered. These are probably some of your clients, but I know Bloomberg let some writers just put their stuff directly on the wire without an editor. Real dangerous. The Sarasota Herald Tribune doesn't have a copy desk anymore. Copy editors are sort of the middle editors. So what they do is send it to Texas, where there's kind of an assembly line of copy editors who don't know anything about the community. So real dangerous. Reuters, I believe, has some stories done by people in India, earnings stories, So it's just getting worse and worse, and I'm not really sure where it's going. But, one thing people don't realize is that there's a real effect on your economy. If you're, say, a small town that's trying to sell bonds, and there's no local paper, you're probably going to pay more in interest because Wall Street knows a lot about crime, and they've realized that, hey, there's a much bigger chance something nefarious is going on here. So that's all I wanted to say.
Any feedback?
As someone who was on the copy desk at the Herald Tribune, I absolutely miss and respect the work of copy editors. I think a lot about what's gained and what's lost when things change.
That's why there's so many typos, misstatements,
For sure.
factual errors.
And all the Herald Tribune alumni in my Facebook feed love to point out every one of them.
Yeah.
I will say that there are things lost when we have fewer journalists and fewer levels of approval.
Yeah.
There are also things gained when publication gets democratized. There are things gained when people with more perspectives on the world have access to a microphone and can say, here's what happened at this meeting. You don't need to be trained as a journalist and paid as a journalist to share what's happening in the community. That privileges certain voices. And when we're able to say, hey, anybody who has something to say about this can say it, I think there are things gained as well. There are also gains and losses for the public, not just for journalism, because it is efficient to say, oh, if this is in the Herald Tribune, then I know that it's part of a system that it's professional journalism and that I can assume things about it. That doesn't mean they're always right. That doesn't mean their stories always get the full range of views. And there might be independent voices who don't have the benefit of that professionalization, who don't have the benefit of 3 editors, who are offering something that the public also needs. The challenge, of course, is that the public can't tell the difference. I sometimes can't tell the difference. I sometimes have links sent to me, and I have to really dig to say, who's funding this work? Who are the people behind this work? Are they activists? And if they are they clear about that? Do I know where they're coming from? So it is very confusing to try to figure out what is credible, but I don't think that how many editors read behind it is the final word about what's credible.
Go ahead, sir.
Hi, I'm John Lambie, and it's really fascinating to sort of be back in the kitchen where the food is being prepared. And I've never heard this perspective at all, but as a consumer, I loved your line that the purpose of journalism is to inform our discretion, or inform our choices, inform our action. And clearly it's getting tighter and tighter and less informative and more entertaining, or whatever's grabbing our eyeballs. And would you guys look at, just talk for a second about the future that you see that might work? And one of the things is institutional memory of a story. Mm-hmm. So how would I know, there's an article about planning or some read zone, but not the context of zoning and the use of multimedia to go along with your stories. So the thoughtful depth of the written word combined with maps and models and new infographics and things like that could really be helpful. And if you guys could weigh in on that, that'd be cool.
Thank you.
I think maybe I'll start on one part is like what universities are trying to do is kind of fill that space. So University of Florida, we have something called Fresh Take Florida, and it's students who work under a couple of professors, one Ted Brightus, who was with the Associated Press and the head of their DC investigative bureau for a long time. And you'll see bylines in papers all over the state that say Fresh Take Florida at the top. So one thing is that journalism programs are trying to fill these news deserts is really what they are. Like, we talk about food deserts, they're really news deserts, right? There's no longer the local paper in town, so nobody knows what's going to go on if the crime goes on in that town. Nobody's going to know that. So one optimistic part is that journalism schools can try to help fill that gap and give these students who need that. But again, they're working under the supervision of somebody who can do that. So that's one possible upside to try to fill those news. But it's really true, like in Gainesville, it was formerly New York Times, somebody else owns it, and these newspapers keep going through. There's so little staff left at these papers to cover anything in a town, and there's very few copy editors. So.
Yeah, I don't know how you create momentum for it, but I would love to wish folks would say, we'll pay for online news content. I think if newspapers had been as foresighted as I think the Wall Street Journal is the only one that really said in the very early days of the internet, we're going to charge for our content. It's valuable. And if more newspapers had made that judgment, maybe they would have survived. But instead, we all started giving away our content, and that obviously was not financially viable. But I think it's going to take folks realizing this. We need this information on a local level. Yeah, it's great that I can buy a New York Times online subscription, but I need to pay for my local paper too.
Getting paid for the news, that's quite something.
It is. In a lot of parts of the country, in a lot of communities, there's a lot of innovation happening around local news. There are a lot of products and publications and newsletters and websites bubbling up that are filling a need that they see that their community has. I'm not seeing as much innovation in Florida. I think we're kind of a trailing market, partly because we still have a lot of people who buy newspapers. We have more traditional news consumers than a lot of other parts of the country do. I think that the one thing we're going to see is that the idea of brand loyalty switches. So the Gainesville Sun, I think, is owned by Gannett, the same people who own the Herald Tribune. It was a New York Times regional newspaper group paper, the same way the Herald Tribune used to be.
Yep.
And their staff is so small at this point. If you would like to be informed in Gainesville, Florida, there are probably other places where you're more likely to find out what's going on than sort of the institutional. There's sort of an automatic trust for a certain segment of the population with that institutional newspaper that is not there for everybody. When I work with a lot of long-standing 100-year-old papers, and I work with a lot of startups trying to tell the story of what their values are. They're often really good. They're really scrappy. And they're really good at saying, here's what the community needs, and here are the values that drive our work, and they know what they're doing. They're not trying to be everything to everybody. They know what they're doing, and I have a lot of respect for that. And it is harder sometimes to introduce yourself to a community as a journalist or a new publication if nobody's heard of you. It can also be easier because you don't have the baggage. All of the reasons people have to be mad at the newspaper that's been there forever, or the newspaper that really only shows up in their neighborhood to cover a crime or something sensational and otherwise pays no attention. The people who live in that community never did trust them, so they're much more likely to turn to a newer outlet. So I think the future of news is confusing because it is harder to figure out what to trust. I have a lot of empathy for everyone trying to figure out what to trust. But I think it's also exciting because there's a lot of innovation and creativity happening.
Well, with that, our spring fund drive is coming, getting paid for the news. Any other questions to the panelists? Go ahead. Please go to the microphone.
I have an interview show on the radio, and but I have as guests people I admire. So I don't talk much. I want them to talk and express their opinions because I admire what they're doing. But they're advocates and they're passionate. If one of my guests says DeSantis is a crook or something like that, am I, the station, liable for that, or is he, or he's just expressing an opinion? But that's all I have on my show is opinion. This is wrong. This prison reform is right. This bill system is wrong. Is that okay? Opinions, one person's opinion. Any restriction on that?
Yeah, I mean, the opinion argument is going to be the first one to make for sure, because the mere fact that he's your guest does not immunize the station.
Okay.
You know, you're responsible for your content.
Okay, but if he has an opinion.
But if it's an opinion that he's expressing, and remember we talked earlier about the Patrick Reed case, we would cite those cases that are in that opinion, court opinion, for the idea that an opinion is protected and can't be the basis for liability.
It's mostly opinion.
There you go.
It's
there
like
you go.
filmmakers and authors and professors. It's opinion.
There you
Okay.
go.
I just want to make sure.
And generally, name calling is not actionable also because, again, loose figurative rhetorical hyperbole. So a good example, one of the questions that comes up a lot now is calling somebody a racist. Is that defamatory? And the word is used so loosely typically that it's non-actionable. But if you associate racist with some specific actions that somebody engaged in, he's a racist because he gave lower grades to the black students than the white students and some things like that, then you might get there. But generally, like you said, you know, the person's stupid or something like that. That's just an opinion. Yeah.
Yeah, that's key. We want to keep in mind just saying this is an opinion
doesn't.
I think Clay's a crook because I saw him robbing the First United Methodist Church offering plate last week. That's a problem. Okay.
So what would he do if one of his guests said, "I saw Clay robbing the church the other night,"
and he didn't hit the dump button in time?
Right.
Right. Yeah. If he didn't hit the dump button in time, then that's a problem. I mean, I think you want to try to correct that as soon as you can, and try to find out why the person said what he did, and hope you don't get a demand.
Thank you. And Jesse's going to work on a dump button for us. I understand.
Thank you so much to the panelists and to the audience with great questions. If you consider engaging with journalism, you know how to reach me. news@wslr.org. We're always looking for community reporters, so please contact me if you feel like it. We have our last event of the series coming up on April 2nd. It's called Community News and Democracy, that promises to be a bang with which we're going to go out with this series. So please reserve your agenda, April 2nd, the last of the Public Newsroom series. Thank you again. Please fill out the Florida Humanities Questionnaire on your table, and I hope to see you again soon. Don't hesitate to talk to the panelists. Thank you, thank you.
And buy a sunshine manual.